Okay, thank you everyone for coming. I'm George Moxery. I direct the Firearms Research Center here at the University of Wyoming College of Law. First of all, our apologies again for the technical difficulties last week. Zoom was just not cooperating with us, and at some point it got late enough that we had to call it. So our apologies for that. Thank you very much for attending today. If there's someone who was here last week, um, who didn't make it today, but you think might be interested, please do feel free to let him or her know that our technical difficulties are solved and that everything is working today. So today we've got Clayton Melinkovich with us. He's going to talk about mental health and firearm access. Um, Clayton is a graduate of our own University of Wyoming College of Law, and he is in his first term as county attorney for Sublette County. His practice experience includes civil litigation, criminal litigation, um, both on the prosecution and defense sides. He has two daughters who are active in sports and their respective schools in Pinedale. And he loves mountain biking and skiing and all things outdoors. So with that, I will turn it over to him. If you have any questions, please put them into the Q&A feature that you have in Zoom. It should be on the bottom, just under the presentation. And I'll pass the questions along to Clayton. Thanks very much, and Clayton, welcome. And with that, I will turn it over to you.
Thank you, George, and thanks for having me. This is a great opportunity to present with you all. This is also a new experience for me, presenting over a webinar. Usually, if I'm presenting, it's in a room and we can have a conversation and we can collaborate a little bit more to get towards some joint learning. So we'll see how that goes today. This slideshow I've created, hopefully you all can see that. These are pictures that I've taken in my travels around the state of Wyoming. Usually I make participants try and guess the county of where these pictures are taken and then tell me the county name, the name of the county seat, and then the county number on the license plate designation. I understand that we have folks with us today that aren't from Wyoming. I understand that we have folks from Wyoming that includes both licensed practitioners, licensed attorneys, and then also non-lawyers. And then I also understand that we have attorneys throughout the country. I do know that, so it sounds like we've got a pretty varied audience. I do know that we do have one helicopter pilot from Texas, so that's kind of interesting to have here with us today. When I was working on this presentation, and I was talking to a friend of mine in Casper about this. That person was like, "Oh, I want to join and watch." And I said, "No, because then you'll see how dumb I am." And they were kind enough to say, "We already know how dumb you are." So I'm trying to set that bar nice and low for you all. Uh, this presentation was born out of a conversation about what it looks like with firearm access for individuals with mental health concerns, largely individuals with suicidal ideation, things like that, um, and where that mixing is with the state's ability or authority to prohibit a person who is in a dangerous situation from having firearms. Uh, Actually, they reached out to me and say, "Hey, do you know anyone who's an expert that could talk about this?" And then they ended up asking me. I'm not sure that I'm an expert, but we will certainly talk about that. In building this presentation, it ultimately ended up being a lot more about current firearm rules in Wyoming, rules and laws, including some legislative updates over the past 10 or 15 years. So that actually ends up being the lion's share of the conversation, but I think that context is necessary to talk more about the mental health piece. And then I will go in. So I'll start with mostly firearm regulations in Wyoming. If I'm telling you something you already know, uh, I apologize. And then we will get into that intersection between firearm legislation and mental health legislation and the actual logistics of how that all works. As George mentioned, I am a prosecuting attorney in Sublette County, Wyoming. One of the things that all prosecutors do is generally cuss the legislature, not necessarily for their policy or anything else like that, but for their lack of clarity in statutes. And then oftentimes we'll bring this up to our legislators and say, hey, can you clear this up? And they don't always choose to do so. And firearms is not immune to that. We have so many interesting questions that still remain about what is the legislature actually trying to tell us about firearm possession and use in Wyoming. And we'll get to those as we go. Since nobody can guess on this picture is actually taken from the top of Medicine Bow Peak, which is actually in Carbon County, Wyoming. And for those of you that are not in Wyoming, it's in the south central area of Wyoming, just on the northern side of the Colorado border. This is actually on a county line. The peak that you can see is in Carbon County, Wyoming, where the county seat is Rawlins. The license plate designator is 6. Uh, and the lake is actually in Albany County, and we'll get to Albany County later. Okay, so I wanted to talk a little bit to start out is with our base of where the like where does regulation of firearms emanate in the state of Wyoming? Under 68401, this is the statute clearly designates that the state legislature is the be all and end all when it comes to uh, firearm regulation in the state of Wyoming. Prior to 2025, it actually used the words the state, and it says that it was the firearm regulation within Wyoming was preempted by the state. I'll talk a little bit about that. In that statute 68401, they have created a couple of exceptions and they note them. So in Title 23, 23.1302, they note that as an exception. And what that's actually doing is that's the enabling statute for the Game and Fish Commission, and it outlines their rulemaking authority. Essentially, it allows the Game and Fish Commission to develop rules and regulations as to what firearms can be used for the taking of what animals. And so that is firearm use, possession, regulation. And so they've delegated that authority to the Game and Fish Commission. They've also, in 15.1103, they've delegated that authority, and I think I actually have a slide. My next slide is on that one. Nope, it's not. So in 15.1103, that is the statute that talks about the authority of municipalities, of what they can and can't do. And as I'm thinking about it, there's a slide later on this, but it outlines that they have the authority to suppress riots and other conduct that harms public safety. So that's not specifically mentioned that you can regulate firearms, but under that idea of conduct that harms the public safety and health, municipalities have what's alluded to as the authority to do that regulation. But all other authority is by the state legislature. And when we get into this, well, the first thing I wanted to start with is through the criminal offenses, because that's generally how the legislature is that they regulate conduct is through criminal legislation. 68101, it talks about it prohibits the use of a firearm while committing a felony. So for example, this could be an armed robbery. You still have the underlying robbery charge. Robbery is theft through the threat of violence. If you're using a firearm with it, you're also in violation of 6101. But this also could theoretically be the use of a firearm when committing any felony. So if I'm if I'm selling methamphetamine to George to support his habit, and I am using a firearm while doing so, that could be violation of that. So that's one of those pieces. We also have 68102, which prohibits the possession of firearms by felons. This, in a recent legislative update that I'll talk about a little bit later, has also included a misdemeanor violation previous to 2020, I think, excuse me, I think 2021, but I note it later. We just had a felony statute. It was a felony violation, and that was for those who were in possession of, or those who were convicted of a violent felony. And then individuals who were previous to that who were convicted of a non-violent felony, it was not a violation in the state of Wyoming. And then we added a misdemeanor violation recently, and I'll talk more about that. And then 68103 outlaws the possession, manufacture, or transport or sale of a firearm with the intent to harm. That's a pretty tough one from a prosecutor's perspective of being able to convict a person of that. It's a specific intent crime. Specific intent crimes are extremely difficult because you have to basically prove beyond a reasonable doubt what a person was thinking and what they were intending to do. So just imagine that George is making a firearm. I have to prove that he's making it with the intent to harm someone, um, which can be difficult. And then you have 68104, which is the unlawful carrying of a concealed firearm. A big chunk of my presentation today will be about that, about concealed carry. That's where a lot of legislation has been surrounding a lot of legislative changes, and this is probably our hottest topic is concealed carry. And then, of course, aggravated assault. It outlaws the threat of violence with a deadly weapon, which can be a firearm or any other deadly weapon, but that requires a threat. And then lastly, reckless endangering, which requires the pointing of a firearm in the direction of another person, regardless of whether or not there is a threat. So that's kind of our overarching weapons offenses that exist in Wyoming. Because we're going to talk about concealed weapons, I want to talk about like what is a concealed weapon. This is one of those things that's fascinating, is that the legislature spends a lot of time and effort talking about what you can and can't do with a concealed weapon, but they, in their infinite wisdom, have chosen not to tell us what what it means to have a concealed firearm. And I do want to back up, just tell you guys these other pictures. Since we have folks that are not from the state of Wyoming, this is my shameless plug to try and encourage you to come visit our beautiful state and spend your money. This picture here, 2 slides back, is the Wind River Canyon which is in Hot Springs County. The county seat is Thermopolis, and that county number is 15. This here is the top of the Beartooth Highway, which is interesting because Montana tries to claim that the Beartooth Highway is theirs. It is clearly ours. The pretty parts are in Wyoming. That is in Park County, which is county seat is Cody, and the license plate designator is 11. If you have not driven the Beartooth Highway, I strongly encourage it. So now we're back to this slide. So the legislature hasn't given us a definition, and one of the things that happens when you're practicing law in the state of Wyoming is that you realize that uh, our our library of Supreme Court cases is pretty thin. Supreme Court has not necessarily dived into this question and given us a good solid answer. I have advised my client, which is the Sublette County Sheriff. I've given him this advice when he's talking to his patrol and his deputies for that purposes. I've advised them that a concealed carry means that it's a firearm that is worn or carried in your bag, purse, whatever, on your person and is positioned in a way to intentionally make it hidden and not readily visible. I've also advised that if a person has a gun on an exterior holster, they threw a jacket over top of it because it's cold outside, and without the jacket, it would ordinarily be visible, but that's not a concealed weapon. Um, if it's obvious under an article of clothing, it's not concealed. When in doubt, consider it not a concealed weapon. Um, and this is mainly from the prosecutor perspective of proving beyond a reasonable doubt that a person is carrying a concealed weapon in violation of the statute. This picture is taken in northern Lincoln County, um, which is on the west side of the state. This is pretty close to the Idaho border. Lincoln County this county seat is Kemmer, and the county designator is 12. And this is my dog Boris in the background for you folks that like dogs. Um, so we get into the concealed carry. The legislature, first and foremost, outlines who can carry a weapon, and then they go through and they talk about where they can carry it. And of course, backing up, carrying a concealed weapon in violation of that 68104 statute is a misdemeanor. There's been a lot of evolution over time, and that's kind of a lot of what I'm going to talk about today. Prior to 2010, uh, the only folks that could carry a concealed weapon were permit holders. And Wyoming is a what's called a shall permit state. It is not a may permit state. Those of you who have been researching firearms for a while know what that means. Essentially, it means that if you check the boxes on your application that the state, or more appropriately, through the sheriff of your county, uh, through the background check of a sheriff in your county, that they must issue you a permit. Other states that are may issue have a application process, and they say, hey, well, we'll think about giving you a permit if you ask for nicely and you give us a really good reason as to why you would need it. So that's a may issue state. Wyoming is a shall issue state. So for discussion's sake, in previous to 2010, you had to check certain boxes in order to qualify for a permit. And you could not carry a concealed weapon without the actual permit itself. Prior to 2010, you had to be 21 years old. That has not actually changed. You could not have a felony. You could not be 922G disqualified. That's a reference to the federal statute. And you had to live in Wyoming. And there were some other requirements as well. But you had to live in Wyoming for 6 months prior to your application of the permit. In 2010, oh, and previous to 2010, you could possess a concealed weapon in Wyoming with an out-of-state permit, so long as the laws were similar. So that reciprocity required an analysis to say, okay, you're coming from Idaho. Does Idaho's concealed carry laws, are they analogous to Wyoming's concealed carry laws? And we did this from the perspective of, well, if we're going to honor your Idaho permit, Idaho better honor our Wyoming permit. And that's how that reciprocity worked. As you can imagine, that was pretty difficult for a normal citizen to understand. I actually worked on a project when I was in law school on with the Attorney General's office, trying to nail down which states we were reciprocal with and which we weren't. And it was extremely difficult based on the language of all those different statutes. In 2010, they eliminated the reciprocity analysis. So they got rid of that requirement that the laws be similar. So prior to 2010, for discussion's sake, a person in Arizona could get a concealed carry permit, but their requirements were different than Wyoming's. And since you couldn't essentially carry, it was not reciprocal. So a person shows up in Wyoming with an Arizona concealed carry permit, it doesn't work, it's not valid. And likewise, the same for Wyoming person were to go to Arizona carrying their concealed weapon with their permit, Arizona was not going to honor it. Since 2010, they eliminated that analysis. Now, so long as you have, or past 2010, as long as you had a permit in that state, you were good to go, regardless of what the requirements were. So you could have a May issue permit in California, and you could carry a weapon in Wyoming. And they also added a few other prohibitions on folks that could get a permit. They added B, V, A, and C, and I'll just tell you what those are real quick. B, V, A, and C says that you can get that permit so long as you has not been committed to a state or federal facility for the abuse of controlled substance within 1 year prior to the date at which the application for the permit is submitted. And then C is that prohibits folks that are convicted of a misdemeanor violation of Wyoming Controlled Substance Act or similar law of any other state within a year prior to the date. Now, interestingly enough, both of those are addressing controlled substances and addiction. You still have a prohibition on a person who is, or you still had at that time, prohibition on a person who is an unlawful user or addicted. Um, Okay, then we go on to 2011. Um, it added a provision in 2000. Wait, was this 2011? Give me a second. These dates are all kind of coming together for me. Yes, so it was 2011. Sorry. 2011 required eliminated the permit requirement. So essentially, it said, hey, if you otherwise qualify for the possession of that you could get a permit, we're not going to require you to actually get one, but you still had to check all those same boxes. You still had to be 21. You still couldn't be a felony. Yeah, you still couldn't be 922 disqualified. All of those same prohibitions, including being a resident of Wyoming for 6 months. So they said, hey, you know what? We're just going to let you carry a permit, even if you don't need to. And at that point, a lot of people in Wyoming said, yeah, I guess I don't need to worry about getting a permit because the incentive went away. However, from a reciprocity standpoint, if you wanted to carry a concealed weapon in another state, you would still want to have a permit. 2016, there were some changes in terms of the application process. Let me back up. This picture was taken in my county, Sublette County. This is the northern of the Green River Lakes, and that's Square Top in the background. Sublette County is County 23, and Pinedale is the county seat. Um, Moving on, so 2016, in the application process, you have to go to your sheriff and your residence. You have to basically be a resident of the state of Wyoming. In 2016, they said, well, hold on. We've got military families who are Wyomingites and they are far-flung all over. We want to allow them to get a Wyoming permit. And so it created that process to allow them to do it. And then in 2007, they cleaned that process up. Like happens with most new legislation, they found some problems and then they cleaned it up a little bit in 2017. And then they also added in Title 21 where schools could authorize teachers, other volunteers to carry weapons. And then that was a whole, whole new statute and whole new rules. 2018, they eliminated. So let me back up in the structure of the way that Wyoming's concealed carry permit it's the foundation on it. You start out by saying no one can carry a concealed weapon unless you have a permit. And in order to get a permit, you have to qualify as follows. Then, like I say, in 2011, we said, nah, you don't need a permit. Then in 2000, and then from there in the statute, you go down and it says, hey, even though you've got a permit, there's still some places that we don't want you to carry a gun. And that's in paragraph T. T is in Tom in 6A104. And it goes through and it lists you can't go here, you can't carry here, you can't carry here. Well, in 2018, and if memory serves, there were some attacks, some firearm attacks in some churches nationally, and the Wyoming legislature responded and said, you know what, we want you to be able to carry a gun in church. Previous to 2018, the prohibition, it said you cannot carry a gun in a place of worship without, and the language they use is like the person in charge. I'm using pastor just to shorthand. It doesn't actually physically say that in the statute, but that was the essence of the law. You can't carry a gun to church unless you have permission of the pastor. Um, 2018, they said, we don't care what the pastor says because you may have a pastor that doesn't like you or doesn't like guns and they're going to tell you not to. We want you to carry a gun in church. Go right ahead. That was 2018. 2020, that. They cleaned up that the military families one a little bit more. Then they did some random administrative stuff, changed some fines, some things like that. This picture was taken in Teton County, which is just north of Sublette County. Jackson is the county seat, and the county designator on the license plate is 22. This is actually taken from the top of Teton Pass, and you're looking across the valley, and you probably can't see my cursor, but above the colon, following 2016 at the top of the page. That is Sleeping Indian, I believe is the name of the mountain right there. Or yeah, I think it's Sleeping Indian. I confuse it with Sleeping Lady, which is a mountain in Alaska. But yeah, so that's Teton County. So then we go through, I want to talk a little bit about that school district one, the 213132. And this is where they created that rule and it went through and it created a rulemaking process for school districts to go through and create rules on who can carry, when they can carry, how they can carry, something to the effect of, yeah, you can carry if you have a lockbox. Like for example, on my desk, I have a lockbox right here that's bolted down to the desk, can't be taken, and inside it I have a firearm, something like that. If you were to create a rule and say, hey, yeah, you can carry it so long as you have a lockbox in your classroom that nobody has the combo to, a variety of things. There were a few school districts that took advantage of this. Not all did. The only school district that I'm aware of that took advantage of this was Fremont County. And I recall walking into a volleyball tournament and seeing a sign on the door that says, hey, FYI, teachers have guns in this school. It, of course, said it much more lawyerly than that, but that was the essence, and said, hey, teachers could have guns. And then in 2025, this year, that was um, that was repealed. And there's some stuff I'll talk about later. It eliminated that and said, hey, for all intents and purposes, it changed it. It changed the language in 104T Romanet 9. And it uses the prohibition. It used to say, I'll put it right here. It used to say any elementary school or elementary or secondary facility. That's what it said prior to 2025. Right now, it currently reads, and I will read it. And just so you're aware, paragraph T says, no person authorized to carry um, shall carry into the following places. And so it used to say any elementary school facility, and now it says any elementary school facility if the person is enrolled as a student at any elementary or secondary school. And I've kind of posed a question there at the bottom for our legislature when they want to think about cleaning it up. Do they mean, or I guess the question then becomes, can a homeschooled 16-year-old carry a concealed weapon into a school facility? I think it's a valid question. I have my thoughts on what is a student enrolled in any elementary or secondary school. What is that? Are they enrolled in an online school as a homeschool student? Are they traditional homeschool? What does that look like? I think that may be something our legislature wants to address. This picture was taken in Sweetwater County. These are the Kilpecker Sand Dunes. Sweetwater County is in the southwest corner of the state of Wyoming. In that back corner, you unfortunately can't really see it. It's kind of buried by the word teachers, is the boar's tusk. It's the remnants of an old volcano. Um, but this is a giant sand dune area. If you've never been there, it's pretty fun to play around. Sweetwater County, the county seat is Green River. Many people get it confused and think it's Rock Springs because that's where most people live, but it is in Green River, and the county designator is 4. So back to our changes in concealed carry. We've got in 2021, the legislature recognized that question of whether or not a person lived in Wyoming for 6 months got to be pretty tricky. For example, if you've got sheriff's deputy or law enforcement officer that comes in contact with a person and realizes, oh, this dude's carrying a concealed weapon. The question is like, well, do they qualify? There's a lot of those questions that come up, and one of those was the residency, and that gets pretty tricky. And the way that the legislature did this is they flipped up a little bit of the way the statute was structured, and they switched out B2 for B1, I mean B1 for B2 in the statute, but they still required United States residency in the United States, which I think poses a question if you are familiar with or thinking from it from the immigration standpoint. Does that mean a lawful permanent resident, a person here on a visa, or does it mean a person who lives here? What does that look like? I think that's a question that I would love the legislature to address for us, especially from the prosecution perspective. That was your 21 change. 2024, it we had some changes for gun restoration rights in 2024 that changed and allowed folks that were convicted of a drug felony um, to qualify for that permit. And then in 2025, mainly, there's some big stuff in 2025. Largely, we had the differentiations between permit holders and non-permit holders on where they can carry. So back, if we're thinking back to, I'm sorry, I gotta get a drink. If you think back to the way that the concealed carry statute is structured, you have that nobody can carry unless you are one of the following people: permit holder, and it does include law enforcement, some other things like that. But you have permit holder, some other things, and then and then those who would otherwise qualify for permit but don't have one. 2025 is the first time they change it and say, well, hold on. You, permit holders can carry here, but others can't. Now, the main difference between a permit holder and a non-permit holder is that the permit holder has had to go through and paragraph B Romanet 7 applied to them. But B Romanet 7 doesn't apply, excuse me, to just any other person that's going to carry with, or what's called, I guess, referred to as constitutional carry. They weren't subjected to B Romanet 7. B Romanet 7 is your firearm course requirement. In order to get a permit, you have to demonstrate familiarity with the firearm, so on and so forth. And it goes through what that looks like, and it has exceptions and everything else. But so essentially, the legislature is saying anybody can carry in these places, but only those who have demonstrated familiarity and proficiency with a firearm can carry into these other places. And that's been our main differentiator in 2025. There's some other things on the rights restoration and some other stuff I'll get into, but from the concealed carry perspective, that's the main thing in 25. And here's what they did. They essentially said that anyone can carry in those places that are not prohibited by T. Um, so you uh, anyone these are places that are still prohibited to anyone. Um, place used for law enforcement, that doesn't matter if you have a permit or not. Detention center, doesn't matter if you have a permit or not. Courtroom, still doesn't matter if you have a permit or not. The judge can actually carry a permit, I mean, carry a concealed weapon, and he or she can decide who else can carry one. And you can't carry your concealed weapon into a bar. Um, then your permit holders are prohibited or are allowed to carry into public schools, college athletic events, uh, colleges, college campuses, and then also high school and college athletic events that don't sell alcohol. Those of you who are not familiar with the state of Wyoming, you'll probably recognize that there's a couple big, there's the largest athletic event areas in the state would be at the University of Wyoming, the football stadium and the basketball arena. Both of those places provide the sale of alcohol. So you can't carry a concealed weapon into the football game, regardless if you have a permit or not. I have some asterisks over athletics, government meetings, and generalized athletic events. And I'll circle back to that when we get to our kind of the wrap up at the end. But I just want to put a placeholder here for that, and so you're thinking about that differentiation of where people are prohibited from carrying a weapon. Um, Also, what happened in our I don't know why I have 201 there because that's not the right statute. Um, no, it is. I take it back. Um, no, I lied to you. That's not 201. It's 68105. I was reading the statute page wrong on my book. Um, In 68105, this is the brand new statute for 2025. They specifically allow the school districts to still make their rules regarding employees and volunteers and when they can carry and when they cannot on any facility owned or leased by the school district. So backing up, we looked at the repeal of that Title 21 statute that said that school districts that teachers and everybody else can carry. They repealed that because what they essentially did, and this is in the 68105, known and cited as the Wyoming Repeal Gun-Free Zones Act, is they essentially said if you have a permit, you can carry into the school. So here they're giving school districts the authority to regulate their teachers and volunteers, and they've said that students at that school can't carry, but there is no authority for a school district to create rules on anyone else carrying who is not a volunteer or a teacher. I mean, or an employee of it. So, for example, if I'm going to the school to speak at a career day, um, am I a volunteer? What does that look like? Probably they can control me there. I'm a volunteer, I'm in there. But if I'm going for parent-teacher conferences or I'm going to an athletic event, the school district doesn't have the authority to control, and I'm saying me because I'm a permit holder for the state of Wyoming in the state of Wyoming. The board of trustees of the school district can't tell me how to carry a gun, what to carry, so on and so forth, or have a lockbox or anything else. Now, it's interesting because I'll boil down on that for a second later on. But so that's one of the other things that changed in 2025 is it gave the school district the authority to create rules. This is where we get into our question of the difference between open carrying and concealed carry. Um, a lot of those prohibitions we've talked about only apply to concealed weapons. What does that mean for open carry? Backing up, we looked at municipalities having the authority to regulate conduct that could pose a risk or disturbance to the public health and safety. Theoretically, that authority could be that a municipality could say no open carry. Has any municipality in Wyoming done that? I don't know. I don't think so. I have yet to see a municipality in Wyoming that has used that authority to prohibit the open carry of firearms. So we've been talking mostly about concealed carry. The Wyoming legislature generally does not prohibit the open carry of a weapon. Now, here, 65209, they've said you can't take a gun into a jail. That would mean, open or not, regardless. Open carry, you're still prohibited by federal law from carrying a gun into the school in an open carry perspective. Now, granted, federal law also exempts concealed carry folks if there's a valid permit holder, and that was where the state cleaned that up or made that change, because prior to 2025, the valid permit holders were still prohibited from carrying a gun into a school. Um, I'm just looking at some notes here. Okay. I want to talk about courtrooms. Right now, the Wyoming Supreme Court Rule 6, it says specifically, so you still have your prohibitions in T. In T, it still says courtroom. And the Supreme Court has made a rule that says you can't carry dangerous weapons into courtrooms. We get into this question in what does it mean to be the courtroom? In Title 5, 511101 goes through and it gives the authority for the Court Security Commission and creates a body by which a board of individuals in each county that acts as the court security commission for that county, and then there's an overarching state court security commission. And so in this 511-101, they kind of promulgate, they say, here's what the court security commission can do, so on and so forth. And that in that they can make recommendations. So the state level court commission can make recommendations to the county level security there. In there, one of the standards that was put together by the state level court security commission in 2009, if I'm not mistaken, essentially recommends that local court security that those court security commissions define what the courtroom is up into and including the entirety of the courthouse and the curtilage. So some county court commissions have said, well, the entire courthouse is the courtroom. And Rule 6 says you can't bring a gun into the courtroom. Also, paragraph T says you can't carry a concealed weapon into the courtroom. Doesn't say anything about open carry. No prohibition on openly carrying a firearm into a courtroom, other than Rule 6 of the Wyoming Supreme Court. And then you also have this, I guess I would call it a inferred right under the Court Security Commission. But I guess I would pose the question, and I have posed the question to the Attorney General's office on this issue of, okay, is that the state legislature that's making that? Because we're essentially a couple layers removed. An interesting question. Now, understand, at the time that we're thinking about this, the 68401 talked about the state having the authority and that the judiciary was part of the state and that the firearm regulation was preempted by the state. And so the Wyoming Supreme Court, the judiciary, is part of the state. So theoretically, in that regard, the Wyoming Supreme Court had authority under the statute to regulate firearms in their facilities. Now, as of 2025, it specifically says that it is preempted, any regulation of firearms is preempted by the legislature themselves, so not the judiciary. So what does that look like? Does the Supreme Court rule that says you can't carry guns into a courtroom, does the Supreme Court still have that authority? I guess if you were to ask the Supreme Court if they had the authority, I'm anticipating they would probably say, of course we do. But I digress on that one. So that it creates some questions as to what does that look like for authorities as to where you can carry a weapon. And backing up, keeping in mind, that's a question on your open carry. You're still prohibited to carry a concealed weapon into the courtroom, but are you still prohibited from open carrying into a courtroom? I'm posing the question. I'm certainly not giving an answer, but I think it is a question that comes up based on the legislative change of 68401. We are 12:45 and we are halfway through our slides, so we're going to pick up the pace. Again, talked about open carry. Towns have that authority. I completely skipped over where this picture was taken. This is Uintah County, just north of I-80. Uintah County is County 19, Evanston. The Uintah County attorney gets pissed at me every time she sees that slide because she's like, couldn't you have found a prettier place in Wyoming, in Uintah County to take a picture? That's the picture I took. This picture is in Weston County. It is, so the new county seat is Newcastle. This is my favorite courthouse in the entire state of Wyoming. I think it's beautiful. So anyway, so as we're talking about, towns have that authority, prevent the riots, disturbances, disorderly assemblies, so on and so forth. Again, I have yet to see a municipality that has done that. 68105. This is the new statute. This is the Repeal Gun-Free Zones Act. It goes in there and it says nothing in this statute shall be construed to prohibit private property owners. 100%, that's great. Private property owners already had that right. And then in 3, it says prohibit a governmental entity from prohibiting open carry, display, or wearing of firearms in its facilities. So this statute says this statute doesn't prohibit it. But what is our fundamental understanding of what local government authorities have? Wyoming Supreme Court has been emphatic on this, that they have said Counties, municipalities, other government entities only have the authority granted to them by the state. They have no sovereign authority in and of themselves as a government authority. So although 68105 says it doesn't prohibit them from doing it, I have yet to find anywhere that provides a county the authority to do what this is saying they're not prohibited from doing. So yeah, it's saying you can't do it, but there's nowhere that says they have the authority to. Okay. And sorry, this is Washakie County, just above 10 Sleep on Highway 16. Washakie County is County 20, and the county seat is at Worland. Here's an interesting one to be thinking about when it comes to regulation of firearms in Wyoming. There's a specific statute here, 68404, that goes through and talks about and defines firearms that are made in Wyoming and that those have not been in interstate commerce and therefore federal law does not apply to it. Interestingly enough, there are specific unique restrictions for possession and purchase for a made in Wyoming firearm that do not apply to any other firearm. It's actually, you have less rights with regards to a firearm made in Wyoming. But then, of course, the legislature also said it's not lawful. They said you have to do all these things in order to purchase or possess it, but they also did not create any type of criminal penalty, so it doesn't really matter. Okay, I am going to, I'm so sorry. I've realized that we're 12:48 and I want to make sure we have time for some questions and I want to respect everybody's time. We have some restoration rights. I'll try and get this slideshow sent over to George and he can send it out. Restoration of rights changed. I'll give you the 10,000 foot view with regards to the misdemeanor that I talked about before, the creation of a misdemeanor, which is a felon in non-violent felon in possession of a firearm is now a misdemeanor in the state of Wyoming. That creation of the statute of a misdemeanor penalty was actually done for the purposes of restoring rights to individuals through that federal and state process. You can't federally have your rights restored unless the state has restored your rights. And you can't restore something that wasn't taken away. So that's why we had to add that misdemeanor to then take away the right for nonviolent offenders to then have it restored. That's 10,000 foot view there. This is Sheridan County. Sorry, I'm going to skip over this. And so we're going to skip over that one as well. Let's go past that. So I want to circle into, and here's the punchline that we're getting to when it comes to, actually, I want to go back to our prohibitions federally. So federally, on the right, they're under 922G. These are our prohibitions for firearm possession under federal law. This is prohibitions on possession. On the left, on the Wyoming side, these are prohibitions on concealed possession, not open possession, just concealed. So we're looking at those situations. And from the mental health perspective, you look at a situation where you have, and it's highlighted in blue, adjudicated mentally incompetent, has been committed to a mental institution or subject to an order of involuntary hospitalization. That's concealed carry, not open carry. And that gets us into our Title 25. I want to give an overview real quick of what Title 25 is. Title 25 is where the state has the authority to involuntarily commit people into mental institutions for the purposes of requiring their mental health treatment. This is individuals who are a danger to themselves or others as a result of being mentally ill. So that's in those spaces, that's a process through the sheriff's office and the county attorney's office that does that and can involuntarily commit people. The other statutes that apply to people's mental illness are in Title VII. These are for our criminal cases. This is where a person can plead not guilty by reason of mental illness or deficiency. That's a question as to whether or not they understood the wrongfulness of the actions when they did it. If a person commits the act of commits murder, for example, commits a homicide, they can plead not guilty by reason of mental illness. And if a jury finds that they were not mentally ill, that they were not mentally right, and they didn't understand the wrongfulness of their actions, there's a process by which that person is punished, not necessarily punished, but they are restored to mental competency. And then you also have when a person is not fit to proceed. So that's if a person is being prosecuted who is just, they have a mental illness, they don't understand what's going on. So these are our spaces where the court has the authority to commit a person, or they make a decision as to saying this person is adjudicated as mentally unfit. That's where our concealed carry rules tell us they cannot carry concealed. But yet, in the state of Wyoming, we don't have any prohibition on a person who is mentally ill from carrying a weapon in an open carry or possessing in their home or in other places like that. Um, I wanted to back up. No, I'm going to go forward. Back to those prohibited possession from and this is where this conversation started, was what does the firearm laws look like in terms of dealing with a person um, who is clinically depressed, having suicidal ideations? Is it possible for the state to step in and take their weapons? It's possible for the federal government to do so. It's not possible for the state government to do so. Uh, State just prohibits the possession from a concealed perspective. And interestingly enough, um, there's some language in that concealed carry perspective, or in that concealed carry statute, that says that you're prohibited from concealed carry if you are currently adjudicated as legally incompetent. Not if you have been, but if you currently are. And through that process of the state hospital, when a person is declared to be mentally incompetent, they go through a process of restoring that person to full mental health. And then the state hospital actually issues an order wherein they make a finding that the person is no longer incompetent. So once that person's discharged from the state hospital, they're no longer currently adjudicated as legally incompetent, and they can possess a firearm, a concealed firearm in the state of Wyoming. Now, they can't from a federal perspective, but then you have your anti-red flag laws that we didn't get into because I didn't have time, and I apologize, that would prohibit any state agency or local government from helping the federal government enforce that. And then also in Wyoming, for the concealed carry, it does say that you have not been committed to a mental institution. It's interesting there because it says has not been, but there's a little bit of a um, they don't jive, because you have currently adjudicated is not a competent, and then has been, because the person who has been committed to a mental institution could then no longer be adjudicated as mentally incompetent. So there's some stuff that we would ask the legislature to clean up for us. Big picture on this, in the state of Wyoming, guarantees for access to firearms have increased. That's in your anti-red flag rules. Areas for concealed carry where they can be possessed has increased. The ability to restore rights has increased. Mental health resources in the state of Wyoming are continuing to decrease. And the state hospital times for Title 25 and other Title 7 commitments, their wait times to get a person in there are not dropping significantly. What I mean by that is oftentimes a person who is in a criminal justice, in the criminal prosecution perspective, if they are going to be evaluated for mental capacity moving forward in a criminal case, those wait times can be 6 months. So that person sits in jail for 6 months while they wait for the state hospital to decide if they are fit to proceed. And additionally, we're seeing law enforcement through training, and then also just through liability concerns, are less and less likely to intervene with a suicidal subject in those situations from an officer safety perspective. It is, I have been told through a variety of law enforcement trainers that it is not illegal to die by suicide, and that they're not going to step in and get in the way of a person that's dying by suicide if they're putting themselves in danger. I'm not saying that this is the viewpoint of every law enforcement entity, but that sentiment is growing. We actually had a situation here, and I applaud this young deputy. He did a great job he had a person who was in a situation who was pointing a firearm at him, threatening him, and also at the same time begging the young man to shoot him in an attempt to die by suicide by law enforcement. And that young deputy did a great job of keeping that man here on this side of the grass with us. So it's not necessarily all law enforcement that are in that space. Um, Lastly, I had some questions I was just going to kind of bring up. Um, these are ones to just think about um, when we're looking at that. Now I guess we'll pose for questions. I'm so sorry I rambled way too long, but I am more than happy to stick around as long as anyone wants to visit and has any questions. So again, George, thank you, and thank you to everyone online for your attention and putting up with me.
So we did have one question, well, comment actually come through by someone, and I'll just read it. It says the Federal Gun-Free School Zones Act should prohibit a 16-year-old from carrying a gun in a school because a 16-year-old cannot get a CCW or a concealed carry CCW permit, which is a concealed carry license.
Agreed. From that federal perspective, yes. Um, I guess I would pose the question, how often do we see federal law enforcement in this state? And I think this is where I'm agreeing with the person. You're exactly right. The federal government prohibits a lot of things when it comes to firearm possession. Uh, but we also have in Title 19, in Title 9, those new prohibitions on and I didn't get into it, I'll talk a little bit of it now, um, that prohibit law enforcement agencies in the state of Wyoming from utilizing any funds that are derived in the state of Wyoming. And that would also be your ad valorem taxes that are collected for property tax, severance taxes, everything else. Prohibits those entities from using those funds to assist federal law enforcement. So realistically, in that situation where in the past, law enforcement would come into a situation and they would see that a person was in that space where they were not allowed or they were not there, they would call federal partners and say, "Hey, here you go, FYI," and they would take evidence, they would take statements, take videos, all the things, and they would give all that information to federal law enforcement to prosecute if they wanted to. Even though the statutes don't specifically prevent law enforcement in the scenario that was described about a 16-year-old carrying a firearm into the school, um, law enforcement agencies are very gun shy, pardon the pun, about doing that. There's a lot of fear, especially because, excuse me, those agencies in the new updates to Title IX also are subjected to civil liability. It removes that qualified immunity for those entities in that space. But yes, thank you for the comment. You're exactly right. Yeah, federal law would say that 16-year-old would not be able to open carry into the school.
And one question, which I think will be our last one, very good question. Could you talk a little bit about the process and burden of proof in red flag proceedings? Is it a dangerousness question?
I guess I might be confused on what you mean, on what the person asking the question means on a red flag proceeding. Um, I'm gonna Red flag, by the way it's described, prohibits a person who is adjudicated as mentally incompetent from possessing the firearm. Um, Under the Wyoming law, that prohibition only really affects a person who's possessing that weapon uh, in a concealed perspective. And if there's that situation, they would be in violation of the concealed carry statute, which is a misdemeanor. So then it essentially acts as a criminal violation. And so you have all of the due process rights attached to it, and that burden of proof would be beyond a reasonable doubt. If I'm understanding red flag proceeding to be a proceeding whereby a person's weapons are removed from them, there's only the only ones that really exist in that area um, is a Title 25 action, where through that involuntary commitment process, that court has the authority to order other reasonable restrictions um, that the patient agrees with uh, in what's called under Title 25, 2510 110.1, which would be for required outpatient proceedings. That's where, of course, the person wouldn't be able to possess the firearm if they were committed to a hospital. They're in the hospital, they can't possess a firearm in the hospital. Um, but if that order were to say, while you are in outpatient treatment, which gives a 2-year space, the court only has the authority to grant additional orders as deemed necessary, which could include possession of firearms so long as the patient agrees with those restrictions. So in Wyoming, there's not really a red flag proceeding process. I hope that answers that question.
I think so. Okay. Well, Clayton, thanks very much for joining us. Thank you, all of you in the audience, for joining us. Um, if you know someone that wanted to come today but couldn't, or think that the content would be interesting to that person, it will be up on our website within a week or so in the video library section. And we did register for self-study CLE. So please share if you think anyone is interested and would like to learn about this topic. With that, thank you all for coming. Next month, we will be live streaming and eventually also putting videos on of our fall conference, which is entitled Sparking the Revolution, Flintlocks, Gunpowder, and Policy in America's War for Independence. And there is some CLE available for that. You can find out more about that in the events section of our website as well. Thanks very much, everyone, and have a wonderful weekend. Bye-bye.